All right, looks like we're live. All right, just need to go through our hearing script. Basically, it just goes over the procedure and then we'll jump right into the presentation. This is the July 21st, 2021 session of the Zoning Hearing Examiner docket. My name is David Sturkey. I'm the Zoning Hearing Examiner for the City of Cincinnati, and I'll preside over this hearing. The case before us today is case number ZH20210101. The purpose of this hearing is to allow applicants and opposing parties to testify and offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing unless a party is opted to submit evidence or testimony in the form of writing prior to this hearing. The hearing will proceed as follows. The applicant, the applicant's attorney, or the applicant's agent first present the applicant's case. The public, if there were anyone here from the public, they would have an opportunity to speak after the applicant has presented its case. In the event that anyone testifies in opposition to this application, the applicant will have an opportunity to rebut or offer evidence in opposition to that opposition. After the applicant has been given an opportunity to rebut any testimony, the applicant will have an opportunity to make a closing statement. After all presentations have been made, I will close the hearing. Decisions may be expected within 2 weeks. I may limit or exclude testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt in the spirit to ask questions or make any comments. I may also refuse to consider hearsay testimony, which generally means evidence you want to introduce in such a statement made by someone who is not present at the hearing. In the event of any technical difficulties with video conferencing technology, we'll do our best to troubleshoot those on the fly, but to the extent there's some fatal defect we can't fix, I may continue or postpone this hearing at my discretion. Okay, last thing we need to do is swear in our witnesses here today. So if you intend on providing any testimony at all, making any comments, asking any questions, doing anything other than just strictly observing here today, then you need to be sworn in. Also, if you're this only applies to non-attorneys. So if that is you, if you could take yourself off mute, raise your right hand. Need everyone to answer out loud. Mr. Friedman, will you be testifying at all here today?
It is not my plan to.
Okay, all right. Do you solemnly swear that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, great. All right. Mr. Blocher, are you ready to proceed?
I am. Thank you, Mr. Sturkey. And my name is Luke Blocher. I'm with the Taft, Saints & Hollister law firm here representing the Cincinnati Bengals as the tenant in the Paul Brown Stadium building owned by Hamilton County. Mr. Friedman, just for clarity, for those of you who don't know, is an attorney in the prosecutor's office who represents the county on these matters as well. This is an application sort of for the county and the team together, and this is requesting an expansion of a non-conforming use. I think our application materials lay out the reasoning for the request and also our justifications for the approval. I would heartily agree with the staff report from the Buildings and Inspections Department. I think in short, this is there are two existing outdoor advertising boards on the northwest external northwest portion of Paul Brown Stadium. They were approved through a variety of processes, late 90s, early 2000s. One's a digital board that's 580 square feet. One is a sort of tri-panel movable advertising board that's around 681 feet, I think it is. And this is merely expanding essentially expanding the digital message board portion to 1,119 square feet. So replacing the existing 580 square foot board with a 1,119 square foot board, and then removing the advertising from the other 680 square foot board. So the net result is the overall square footage of outdoor advertising, all of which is sort of currently legally non-conforming, is actually reduced. But we understand and appreciate that in order to be consistent with the code, the expansion of the video board from a 580 square feet to 1,119 square feet does need to be granted a variance. I would note, and so again, we've sort of laid all that out in our application materials, and again, I think it's concurred with through the staff report. And of course, happy to answer any questions about any of the materials or any of those factual details. I would note as well, it was in the materials, the application materials, that there are two other sort of context, or two other regulatory regimes that would apply to this. One is Chapter 895, or potentially apply. One is Chapter 895 of the City Municipal Code, and that is in our application materials, there was a letter from the county and the team to the city manager, in which the city manager agreed this message board was initially constructed pursuant to an agreement between the city and the county relative to the construction of Paul Brown Stadium. And this is, since this is merely essentially an upgrade of that existing message board, this is still being done pursuant to that original agreement, and therefore Chapter 895 doesn't apply because it's being constructed pursuant to an agreement between the city and the county. And there's also, because this is near the highway, there are ODOT regulations that apply to outdoor advertising, and this satisfies those as well, as is given, because there's I think it's something like 1,200 square feet is the for video boards is the limit on the state code if you're near a highway, and this is under that. I would note as well, lastly, that the city manager, the letter with the city manager relative to Chapter 895 compliance or exception, and also the staff report, which recommends approval with certain conditions. Those conditions mirror what the team and the county agreed to voluntarily put in place some certain controls on the message board to make sure that there weren't any issues that would be present from what was on it. So there's a series of rules around how the images can be displayed, and the brightness of them and things like that are the team is committed to, the team and the county have committed to abide by and are part of the condition. So we embrace the conditions from the staff report for that reason as well. And I think that probably is enough of a general statement, and again, refer to our application materials for anything further.
Okay. Thank you. So one just clarification on my part, just to make sure I understand the project. So looking at those two signs that are existing, you're saying that one of those will be removed in order to make way for the expanded the expanded signage?
And removed might not even is probably not the best word. So what's happening is there's the two signs. I'm going to try to pull up the image myself too, but there's the two signs, one of which is the video sign. And I think it's to the left if you're looking at it straight on. That sign, the sort of the structural support for that sign will stay there. And then just the actual board part of it will be replaced. So a bigger board will be put on that same structural support. So sort of physically, actually, the actual building structure is not going to change, except for that you'll sort of pull off one flat board and put on a different flat board that's slightly bigger. And then the panel to the right will be what is now sort of changeable, these sort of tri-panels that can do different types of advertising, is authorized to do different types of advertising, is going to be, those tri-panels are going to be replaced with a sort of fabric that mimics other parts of the wall that are sort of looking from the general eye, look like the wall of the stadium.
Okay. Got it. All right. I think that's all the questions I have for now. I want to give Doug an opportunity to add anything if you would like. Doug?
Yeah, I don't have much to add. I'd just reiterate that this is really just in essence, a net reduction of the existing advertising. So while the one sign is getting larger, the advertising from the other sign is being removed. So they will have less overall size of the advertising space based on this proposal. So we don't have any issues with the request.
Okay. And so it's reducing in overall size, but it sounds like the signage is going to be a little bit more dynamic. Is that right? And is that a cause for concern at all?
So I mean, the video board will be upgraded with more modern technology. I mean, the existing video board has the option of, changing the messages and displays. So, the new board will function in the same manner, but just with clearer images and more options for what that can display based on the size. So, but along with that technology, there are improvements in the lighting as well, which is that last condition that we added, which was, submitted to us in the application, which basically says that video board will have technology that will automatically dim the board so that it's never, excessively bright. So overall, with that additional technology, I think it will be an improvement on the current conditions.
Okay, great. Emily, did you want to add anything?
No, I'm really here for questions. I think Doug's staff report really articulated our position well.
Okay, great. Mr. Friedman, I want to give you an opportunity if you wanted to add anything as well.
No, I think Luke certainly presented everything that needs to be presented. It's pretty clear and concise, and he was right. I was involved in actually the original 1998 agreement, so it's been a long time.
All right, great. Luke, anything based on Doug's testimony or my questions, or in closing or otherwise before we adjourn?
Yeah, I think I would. I mean, just echo what Doug said. I think it was an important point. I'm glad you brought it up. That it will be a bigger and more modern, better technology board. But part of the benefit of that is that the technology is much better at making it less obtrusive. And we actually I actually learned quite a bit about dimming technology in this process, because there was a sort of mutual interest in making sure that there could be a way to govern the brightness that would not cause problems. And we've been working with the manufacturer of this to determine that they're sensitive to this as well. They developed this technology that, as Doug mentioned, is automatically dimming and allows you to set it to a standard that is pretty much universally, or at least in the country, accepted as sort of like the safe standard. And so it's a nice improvement. And then I think the only thing I would say in closing is that the in addition to everything that's laid out about the sort of I would argue sort of minimal nature of this request regarding changes from current conditions, it is a significant technological upgrade. So it will be a much better product that exists, that the public is seeing, and a much better product for the sort of capital status of the physical structure of the stadium. So I think there's a lot of other benefits that aren't necessarily tightly related to whether it's an expansion of a non-conforming use or not, but I think argue in favor of I think there are some of the standards that are listed as things to be considered that are significant improvements that have a lot of benefits to certainly to the applicants, but also I think to the general public's view enjoyment of the stadium.
Okay, great. All right, well, I guess we'll leave it at that then. Thank you guys for your time, your testimony. This will be an approval. Honestly, what takes me the longest with some of these is to actually type up the official findings in my decision. And so typically, as I said in the opening, that's 2 weeks. I'll do everything I can to get this out sooner. I think as you were coming through, you said that you had sort of a tight time frame. Is that right?
Yeah, and for reasons that are appropriate, it took a long time to get to this point, but they are, as the county's the money's been appropriated for this. I think a lot of they've sort of gone as far as they can go without having this approval, knowing that you can then go get the permit. So I think we're not sort of like, we're not about, things aren't about to blow up, but I think there's a lot of benefit to getting it done soon, because they are trying to get this done in conjunction with the upcoming season. And so any expedition you give to it, if that's even a word to describe this, would be appreciated. But we're also, I don't want you to feel, we're not, our house isn't burning down either.
Okay. I'll aim to have this out next week then. If for any reason I can't have it out next week, I will email you. Give you
That'd be, thank you. Thank you.
Emily,
But
is
I
there anything
can-
else we can do?
I was just gonna say, I don't know if we discussed this before, but you can apply for the building permit so that that review process starts.
Okay.
You just won't approve the building permit until the decision's been issued. So all the other reviewers can start their reviews.
Okay, I will pass on it. For all I know, maybe they've already done some of that, but I had been advising all along, we're gonna have to go, this is something we're going to have to go through, and there's good reasons why, and you need to, build that into your schedule. But I will confirm that it will be an approval and that they can go through to get the process started. Thanks, Emily. I appreciate that clarification.
If any other questions come up, feel free to reach out to myself or Emily or Doug, and happy to help.
Great.
All right. Thanks, guys. Have a
Thank
good
you all.
day.
Thank you all.
We are
Appreciate
adjourned.
it.